today as opposed to last week or a couple of days because the room kept being changed on me and I couldn't send information out. I'm Teresa Collett. I'm a law professor here at the University of St. Thomas. Those of you who know about the university, we have a pro-life center that I head here that the university has authorized, that I do most of the work. In addition to my law faculty work, I also litigate in this area. So perhaps I should say, in light of current events, that I am not a medical expert, have never claimed to be a medical expert, but I am a legal expert and have been admitted into courts testifying as a legal expert. So tonight's presentation is on the Planned Parenthood videos and Minnesota law. What we want to do is we want to make sure that members of our community understand the debates that's going on here in Minnesota. And so what we're going to do is open with a short segment, about 4 minutes compilation from the actual videos themselves. These videos were done by the Center for Medical Progress, and they were undercover. There's a huge debate, as many of you know, within the Catholic tradition about whether undercover videos themselves are moral, because of course there is if not an active misrepresentation, there is certainly an implicit misrepresentation about who you are in order to get these. And so there is a division of opinion about whether it's appropriate to use this means under these circumstances. Setting that question aside, however, these videos that are several hours long were edited to make short, accessible presentations of various segments. The entire videos, if you'd like to see everything that was taped during the entire discussion, it is on the website of the Center for Medical Progress.org. So you can see the uncut raw footage on the Center for Medical Progress.org. So the objection that these have been selectively edited, you have the opportunity to judge for yourself. In addition to the Center for Medical Progress, then trying to provide the highlights reel, if you will, to the general public as part of its initial disclosure of what they learned during this undercover investigation, we've gone and selected it even more tightly. So we're only going to show you 4 minutes to start with. And based on assurances I gave at our last presentation, which was on surrogacy and abortion, we have selectively edited so that the most graphic part of these videos will not be part of our display. So hopefully you won't be made uncomfortable with what we've chosen to show you. But we do want to give you a setup. So let me begin by, and part of the problem is we have a little bit of a display issue here. So if I were to go here, there we go. We're going to start.
A lot of people want intact parts these days. They're looking for specific notes, maybe notes, essay. I was like, wow, I didn't even know. Good for them. Yesterday was the first time she said people wanted lungs. And then, like I said, always as many intact livers as possible. People just want
livers.
Some people want lower extremities too, which that's simple. I mean, that's easy. I don't know what they're doing with it. I guess they want muscle. But
Yeah, a dime a dozen.
I'm the medical director for the national office for all of the
Right.
affiliates. So I say, okay, what are you looking to supply today? We've been very good at getting heart, lung, liver.
Are you looking at 8 and 9 week specimens or only second trimester specimens?
10 to 12 week, end of the first trimester. If those are pretty intact specimens, then that's something we can work with.
So that's an interesting concept. Let me explain to you a little bit of a problem, which may not be a big problem. If our usual technique is suction at 10 to 12 weeks, and we switch to using an iPass or something with less suction in order to increase the odds that will come out as an intact specimen, then we're kind of violating the protocol that says to the patient, we're not doing anything different in our care of you. And to me, that's a kind of a specious little argument, and I wouldn't object to asking Ian, who's our surgeon that does the cases, to use an iPass at that gestational age in order to increase the odds that he was going to get an intact specimen. But I do need to throw it out there as a concern, because the patient is signing something and we're signing something saying we're not changing anything in the way we're managing you just because you agreed to give tissue.
Yeah, what we've used in the past is a materials transfer agreement, and that's obviously open to discussion.
So that's a prototype. It needs to say exactly what your staff is going to do, exactly what your expectations are, exactly what your compensation is.
And are we agreed that $100 would keep you happy?
Well, let me agree to find out from other affiliates in California what they're getting. And if they're getting substantially more, then we can discuss it. It's been years since I talked about compensation, so let me just figure out what others are getting, and if this is in the ballpark, then that's fine. If it's still low, then we can talk about it. I want a Lamborghini. I said I want a Lamborghini.
Was that crack? Was that just the little bits of the skull?
Mm-hmm. This one missing one leg. The foot.
Oh, there you go. Yep. You got all of them right there.
Another boy! Another boy! Boy!
So, that gives you a sense of what we see when we go to these. And now, whoops. Normally we have access to the full slide up here, so I'm having to work off of this, so I apologize. It's a little less smooth than we would hope. There we go. So, part of the debate in Minnesota is this sort of provision of fetal tissue to researchers or to whomever would want to acquire it legally permissible? And in Minnesota, we have two laws that are particularly applicable. The first is Minnesota Statute 525A.09, and it is about the ability of individuals to make an anatomical gift. Some of you in the room may be organ donors. I myself am willing to have my corneas removed after I've died and donated in order to help someone to see. So these are the laws that govern under what circumstances can someone donate parts of their body after they die. And it tells us that, subject to paragraphs B and C and unless barred by, an anatomical gift of a decedent's body or part for the purposes of transplantation, therapy, research, or education may be made by any member of the following classes of persons who are reasonably available in the order of the priority listed. The agent, my husband has a power of attorney that would not apply, but he also has a document that would make him my agent in other circumstances immediately before the decedent's death, the spouse of the decedent, adult children of the decedent. Now, none of those would apply to fetuses, but parents of the decedent. So parents of the decedent, in theory, if these fetuses are considered decedents for purposes of the law, would be entitled to make an anatomical gift. And we find that another statute in the same section defines decedent as a deceased individual whose body or part is or may be the source of an anatomical gift. It includes a stillborn infant or an embryo or fetus that has died of natural causes in utero. So under Minnesota law, if a woman miscarries, if there is a spontaneous abortion, there is no question that that woman or the father of that fetus or stillborn child is legally entitled to donate the remains for purposes of research, investigation, etc. Now, this is the general donation law that applies to the parent's decision to make a gift. What is more specific to abortion, induced abortion, is Minnesota Statute 145-1621. This statute was enacted several years ago after 15 fetal bodies were found in a dumpster behind an abortion clinic here in the Twin Cities. And so the legislature said never again. They said in order to ensure the proper and dignified disposal of these remains, we're going to pass a statute. And what it says is that remains of a human fetus resulting from an abortion or miscarriage, induced or occurring accidentally or spontaneously at a hospital, clinic, or medical facility, must be deposited or disposed of in this state only at the place and in the manner provided by this section, and if not possible, as directed by the Commissioner of Health. Hospitals, clinics, and medical facilities in which abortions are induced or occur spontaneously or accidentally, and laboratories to which the remains of human fetuses are delivered must provide for the disposal of the remains. And here's the part that is creating the political fervor: by cremation, internment by burial, or in a manner directed by the Commissioner of Health. The hospital, clinic, medical facility, or laboratory may complete laboratory tests necessary for the health of the woman or for her future offspring, or for purposes of a criminal investigation or determination of parentage prior to disposing of the remains. So in other words, where there is an induced abortion, there are only 3 appropriate means of disposing of the remains of that unborn child. First is cremation. Second is burial. Third is in accordance with a directive from the Commissioner of Health, which there is no directive that would allow the use of it for research generally, nor is the Commissioner of Health in that list of anatomical gift that we saw at the beginning. All right. All of this, however, allows brief investigation, so you can retain the remains if you had a spontaneous or an induced abortion because of some sort of fetal anomaly, let's say at Mayo or at Regions Hospital, which had an abortion clinic for an extended period of time. If they were retaining them for purposes of investigating a condition in hopes of helping the woman or her future offspring, necessary for the health of the woman or her future offspring. There are no other research exceptions in this at all. Okay. So induced abortions require the fetal remains to be cremated or to be buried, although that can be delayed for purposes of investigation that are necessary for the health of the woman or of her future offspring. Now, that's Minnesota law, which is more restrictive in large part because of the circumstances under which we discovered the fetal remains. What we see in federal law, according to the Department of Health and Human Services, is that in order for research carried out under subsection A, which allows the transplantation of fetal tissue or the use in research, and it's not limited to spontaneous or induced abortion, the fetal tissue may be used only if, and here's part of the debate over the consent, if the woman providing the tissue makes a statement in writing and signed declaring, 1, that she donates the tissue for use in research described in the first part, that the donation is made without any restriction regarding the identity of individuals who may be recipients of the transplant of the tissue, and that the woman has not been informed of the identity of the individuals. So if in fact there is some basis, let's say that a woman is in a car accident at her 8th month, and they want to use the fetal remains in that instance, they want to take a heart and donate it for purposes of transplant to a newborn, and the heart will work or the liver will work, then the woman cannot know the individual. This is consistent with most of our other federally funded organ donation requirements. In the case of tissue obtained pursuant to an induced abortion, the consent of the woman for the abortion was obtained prior to requesting or obtaining consent for a donation, because what we don't want is abortion providers to say, don't be worried about whether you're doing something right or wrong. You're doing something wonderful, because think of all the babies that are going to be saved in the future because of what you're doing today. She has to consent to the abortion prior to the fetal donation conversation. No alteration of the timing, method, or procedures used to terminate the pregnancy was made solely for purposes of obtaining the tissue. Recall the conversation in which the woman said, well, we could go to a different type of suction abortion, but that would require some sort of change in what we tell women we're doing. I'm willing to talk to Ian, the doctor who does these abortions, about that, but we have this policy that I don't think is very important about not changing the procedure after we've obtained the woman's consent. Now, she was specifically talking about an abortion that would occur somewhere between 10 to 12 weeks, according to the transcript of the video itself. And that would be consistent with the medical text regarding the description of abortion, the leading one produced by the National Abortion Federation. There are subsequent videos that have more graphic provisions that talk about the use of tissue obtained in late 2nd trimester and early 3rd trimester abortions. In those instances, there was a discussion about the use of digitalis. Digitalis in the partial birth abortion litigation, where I authored the primary medical brief relied upon in the United States Supreme Court in the 2nd partial birth abortion case, which upheld the federal partial birth abortion ban at that case. One of the ways to circumvent current federal law prohibiting partial birth abortion is to induce fetal demise, that's the language used in the textbook and the medical articles, to induce fetal demise prior to extracting the fetus from the woman's body. As long as the fetus is killed prior to removing any part of the fetus from the woman's body, you will not violate the federal partial birth abortion ban. And so there was an interesting dialogue that occurred in the deposition of officials in San Francisco who were among the plaintiffs that sued to forbid the enforcement of the federal partial birth abortion ban, at which time the doctor that directed the abortion clinic in the San Francisco Medical Center that was plaintiff said, we always induce fetal demise by administering digitalis directly to the fetal heart prior to removing the fetus from the woman's body. Now that meant they weren't violating the law, so how did they get to be plaintiffs? They got to be plaintiffs because the Ninth Circuit refused to entertain the question of whether they were violating the federal law. They said, in their opinion, because this issue was not raised by the Department of Justice, notwithstanding the transcript was clear, we don't have to address it. That leads to the question, if you can do these sorts of abortions at 22 weeks and forward, lawfully, simply by administering digitalis or some other death-inducing drug directly by injection into the fetal heart, why did they spend all the money and all the political capital in order to try to defeat the federal partial birth abortion ban. And I'm speculating, but at this point, my speculation is that it was done in order to maintain the availability of partial birth abortion, which allows them to harvest the organs untainted by the administration of these sort of lethal drugs to the fetus. If you inject that into the fetal heart, you have rendered it unavailable for transfer for these purposes. Again, it is supposition on my part, but it is the only explanation that makes sense as to why they would fight so hard on something that was so graphic and that did, as evidenced by poll after poll after poll, move public opinion toward the pro-life position, at least when we're talking about these later term abortions. So, federal law says you cannot alter the method by which the abortion would be done in order to facilitate this sort of fetal transplant, fetal organ transfer, etc. It also tells you that it has to be done in accordance with applicable state law, because as my colleague Autumn will tell you, in Minnesota, part of the defense of what's going on is, well, we're complying with federal law, as if state law were irrelevant. This is one of those cases where the law of preemption, which can govern, there are instances in which once the federal government passes a statute, state legislation is void. That is not this case, because explicitly the federal authorities maintained the authority of the states to allow applicable state law to be much more rigorous on this issue, which Minnesota chose to do. So let me then, if I can get this to do what I want. Let's fast forward here. Come with me.
Okay. And any idea why the other affiliate?
Precure from her clinic on Saturday, because that's the day that they do large cases. Now they do induce fetal demise at about 21 weeks, depending on the doctor. Sometimes
because for BLT, I'm wanting like 18 to 22 weeks.
Right. Yes.
Right.
And that would be fine. So if we had 18 or 19 weeks, then that we could get those to you.
Okay, and it doesn't have digoxin though.
No,
Okay,
it does not.
good. Yeah.
And we always, and I mean, we've been in the business long enough, I can tell if it's been ditched or not. You know, I just look at it, I go,
oh, really?
Yeah. I mean, it has a smell. It's not right. So
wow.
It's just kind of icky.
Yeah.
But, but we also have clinics in San Diego, in Oregon, in Minnesota.
Digitalis, injected into the heart. I can tell if it's been diged or not. That's icky. That's not usable. Primary procurement officer. We have facilities that allow us to procure in Oregon and in Minnesota. With that, I'd like to introduce Autumn Leva, a very talented lawyer, notwithstanding she's not a St. Thomas grad. Very talented lawyer who works with the Minnesota Family Council, who has been working diligently on bringing this to the public's attention, and she'll bring us up to date on where we are.
Thank you, Professor Collett. And I have to say it's a real honor to be here with Professor Collett. She's a hero of mine, even though she wasn't my professor. I went to Regent Law School in Virginia, and one of my professors is actually a friend of Professor Collett. So it's a real honor. So yes, Professor Collett has asked me to kind of give you all a breakdown of what's gone on in Minnesota with regards to fetal tissue procurement, fetal tissue research, the political climate, and those types of things. So I'm really, it's an honor to be here. And I thought, first of all, I'm going to get a little bit interactive with you all. I'm not too far out of law school, so it's kind of fun to be on this side of the podium and asking questions. So hopefully you'll be able to interact with me a little bit. And also, I think about things chronologically, and so I think in a way it's really good to figure out where things have been in the state and where things are going with regards to this issue. So I'll back up a little bit and talk about the 1980s, and Professor Collett mentioned this already. In the 80s, that's when the bodies of the aborted babies were found in the dumpster behind the abortion clinic in Robbinsdale. And after that, there was such a public outrage over it. We know that legislation tends to move when there's some sort of public outcry. So there was a public outcry, and then Minnesota's fetal disposition law passed in 1987, and that's the law that Professor Collett mentioned that governs how aborted babies have to be, how their remains have to be taken care of. And as she said, here in Minnesota, that needs to be in a dignified manner, and we define that as burial or cremation in the state. So we have that in 1987. So then let's flash forward to this summer, and that's when the first Planned Parenthood videos started coming out. The first one was released on July 14th, and there was just, I'm sure as you know, a national explosion afterwards. And I want you to remember that date, July 14th, 2015, because it'll become very important as I move through the presentation. So then throughout July and August, my organization, Minnesota Family Council, worked with an organization called Pro-Life Action Ministries that I'm sure many of you are familiar with. They do excellent work. And some other pro-life organizations. Professor Collett was a part of that as well with the Pro-Life Center here. And we held several rallies right in front of the biggest Planned Parenthood in the state. It's the third largest in the country in St. Paul. We held lots of rallies asking for the governor and his administration to investigate, find out what's going on at Planned Parenthood, find out if this is going on in the state, take a look at what's happening with regards to fetal tissue research. We wanted answers because we saw these videos coming out implicating all sorts of things around the country. We wanted to know what was going on here in Minnesota. And at that time and to this date, the governor and his administration have not responded. So here we have the rally that we held at Planned Parenthood on August 22nd. It was huge. There was a lot of energy and people crying out for the investigation. The media, of course, said there was about 400 or 500 people there. I talked to the Star Tribune and I said, you might be off by a few thousand. There was actually, we had a hard count of over 4,500 people there. So that shows how much this issue has really come to light here in the state, how much it galvanizes people when they watch the videos and find out what's going on. So that was this summer. Then in September, we held a rally. We changed locations. We thought, well, we're not getting the governor's attention at Planned Parenthood, so we're going to move to his house. So we held a rally at his house on September 9th of this year, and we called it the Firestorm Rally. And basically the point was, again, to ask him to investigate. And this time we changed the message a little bit again. We said, okay, fine. If you don't want to investigate Planned Parenthood, because the governor's Lieutenant Governor, Tina Smith, is a former vice president of Planned Parenthood, so we thought maybe he didn't want to go there. So we said investigate all the abortion facilities. If you don't want to investigate just one, investigate them all. We want to know what's going on. We want to know if these baby body parts are being harvested in the state. And again, to no response, but there was a large outcry at the rally, and also it was well covered by the media, which was great. So then, flash forward to September, late September, September 28th to the 1st of October here in Minnesota. And an online news organization that you all should really check out called Alpha News. It's alphanewsmn.com. They first broke the news. They did a public information request to the University of Minnesota and came back, and they found that the University of Minnesota had actually purchased fetal tissue from the years of 2008 to 2014 from a company called ABR. And if you all just remember from the video you saw, ABR, Advanced Biomedical Resources, they have clinics here in Minnesota. You just heard them say that in the undercover video. And apparently the University of Minnesota had been purchasing fetal tissue from them. Now, at the time when Alpha News broke this story, there was no knowledge, because the purchase orders don't say, there was no knowledge whether or not the tissue had come from aborted babies. And as Professor Collett said, if a mother of a stillborn or a miscarried infant chooses to donate those remains under Minnesota law and federal law, she may do so. So there was no knowledge. Obviously, we all kind of suspected that that's what was happening, but the purchase orders aren't clear. I I'm sure you probably can't see the prices from way back there, but it says there's baby liver they bought for $325 each, pancreas $325 each, and fetal lungs for $175. And there are more listed. I didn't show them all on this slide. So very, very high prices. There's a strong suspicion that that's above and beyond just the cost of procuring and shipping those tissues. So then, on October 22nd, some very amazing, very smart University of Minnesota students actually held a rally at the University of Minnesota, and they were basically demanding answers. They said, we want to know where this fetal tissue came from, we want to know what our tuition dollars and taxpayer money is paying for, and we also want you to clarify your policy, University of Minnesota, because your policy is not clear with regard to fetal tissue research. And you have a stricter policy, quite frankly, on researching on animal tissue than you do on human fetal tissue, and that's unacceptable. So the students held a very peaceful rally asking for these clarifications on October 22nd. And interestingly enough, also on that day, Representative Marion ONeill, she's from Maple Lake, she was having a meeting with the University of Minnesota's Vice President for Research. So basically, this is the individual, his name is Brian Herman, and he is the head of all medical research at the University of Minnesota. And that same day, right before these students had this rally, so they knew nothing about this, the Vice President for Research admitted to a Minnesota legislator that they had been doing fetal tissue research in Minnesota for years, and it had been done on aborted babies. And they said, you know what, we refuse to do research on miscarried or stillborn tissue because it's not fresh enough. So we have to use aborted fetal tissue. And we've been doing it for a long time. And quite frankly, we used to buy that tissue directly from the abortion clinic. He said they used to go directly to Meadowbrook Abortion Facility, which is now Whole Women's Health in Minneapolis, to procure that fetal tissue. And indicated that they were going to continue doing that, and that they really had no qualms about doing it. So that all happened on October 22nd. It was a big day. So here you see on the pictures of the signs, question for Kaler, President Kaler of the University of Minnesota. Can you explain $175 lungs, $325 liver, and $325 pancreas? And then on the orange sign it says research on fetal tissue a legal issue, a question mark. They're asking him, and little did they know that their questions were being answered behind closed doors. Well, finally, on October 27th, the Star Tribune finally published something with regard to this issue. Now, it's important to note that to date, to my knowledge, President Kaler and the university have not made an official statement to the press themselves on this issue. But what the Star Tribune did was publish a letter that President Kaler wrote to some of his regents from their Board of Regents who were asking questions, and he responded to them. And the Star Tribune published that, and I wanted to point out some of the highlights. Obviously, I didn't want to put the whole letter in there, but I did want to point out some of the highlights, and this is where I'd like to ask you some questions and see if you can be legal minds like Professor Collett and catch what's missing here. So the first quote says, and again, like Professor Collett, I apologize for having to turn around. The university does not know all of the various sources of fetal tissue procured by ABR. However, ABR has informed the university that it procures tissue from induced abortions at clinics throughout the country, including, up until July 2015, clinics in Minnesota. It does not procure tissue from spontaneous abortions because such tissue rarely, if ever, can be used for research purposes. The same is true of the fetal tissue supplied by STEM Express, that's the other tissue procurement company buying aborted baby parts directly from the abortion clinics, and any other organization that might procure fetal tissue. What do you notice about that date, July 2015? Anybody? Thank you, Melissa, yes. The first video, that's all right. The first undercover Planned Parenthood videos were released on July 14th, 2015. I'm not sure that it's a coincidence that these abortion clinics apparently stopped providing ABR with tissue on July 2015. The second quote says, research with fetal tissue from induced abortions is legal under federal and state law and is eligible for federal funding. Well, we know from Professor Collett's excellent breakdown of the law that yes, this is legal under federal law, but that doesn't prohibit the states from regulating it more strictly. And to date, President Kaler has yet to explain what state law he is following. He's not addressed either the fetal tissue disposition law or the anatomical gift statutes that Professor Collett mentioned. He's given no basis for his legal standing under state law whatsoever. And then finally, I believe the University of Minnesota should stand with its peers, other major research universities and academic medical centers throughout the country who have recently endorsed a statement issued by the American Association of Medical Colleges endorsing the continued legal and responsible use of fetal tissue in medical research. And I thought that was interesting when I first read it through, and I had to read it a couple times. And I thought, well, basically, what the president of the University of Minnesota is saying, yeah, we're doing fetal tissue research. I know we said we weren't doing it before, but we actually are. And we're going to keep doing it because we believe that it's good and because everybody else is doing it. Now, I don't know about you, but that certainly wouldn't have worked as an excuse from me to my parents if I broke a rule. Everybody else was doing it too. And it certainly shouldn't be an excuse that's worthy of the president of the University of Minnesota. On that same day, the Star Tribune also released the response of Dr. Herman, who, again, is the head of all medical research for the University of Minnesota. He's the one who spoke with Representative Marion ONeill and admitted to everything that was going on with the university. And I should also mention that Dr. Herman and some in his staff were the same folks who told Representative ONeill and members of the legislature back in July, when the videos first started coming out, that the University of Minnesota did no fetal tissue research at all. Not just on aborted babies, but zero fetal tissue research. And so, of course, Representative ONeill and her colleagues were pretty upset, wondering why they'd been lied to. And so she had another meeting with Dr. Herman. And then this is the response of Dr. Herman that was published in the Star Tribune. And again, I'd like to ask you what you can pick out from some of his quotes. He says, fetal tissues are supplied by ABR and STEM Express. These suppliers obtain consent for use of these tissues in medical research prior to their donation and operate in accordance with federal guidelines that prohibit them from making a profit from procurement and provision of fetal tissue for their clients. What's missing? Exactly. I'm not sure who said it back there, but that's right, state law. He doesn't address state law at all. According to our review, current university policies do not comprehensively address the disposition of fetal tissue used in research. In order to ensure this tissue is treated with the utmost respect and dignity, the University of Minnesota Medical School Anatomical Bequest Program will immediately begin handling the procurement of fetal tissue and disposal after its use for research. The bequest program oversees the respectful interment or cremation of human tissues donated to the University of Minnesota for education and research purposes. What do you catch there? Well, exactly. They're essentially admitting that they broke the fetal disposition law. They're seeing no repercussions for that. And also, they're recognizing that these tissues do need to be treated in a manner that conforms with the anatomical gift statutes. And as Professor Collett mentioned, the anatomical gift statutes specifically prohibit the use of aborted fetal tissue in research. It can only be miscarried or stillborn. And finally, we understand that research using fetal tissues may evoke strong feelings for some Minnesotans. We respect their point of view and recognize their passion around these matters. However, the University of Minnesota will continue to allow its researchers to use fetal tissue in their research as allowed under federal and state law and University of Minnesota policy. So again, similar to President Kaler, yeah, we're doing it, we're proud of it, and we're going to keep doing it because everybody else does it. So, and again, no mention of how this is legal under state law. So finally, just recently we learned from actually the purchase orders themselves, some of the correspondence that was posted in the purchase orders between ABR and the University of Minnesota and Representative Marion ONeill, who had the meeting with the Vice President for Research. We learned exactly what the University of Minnesota is doing with the fetal tissue that it procures. And it's doing the same thing that the University of Wisconsin is doing. It's taking the fetal tissue, so the fetal livers, the fetal heart, the fetal lung, what have you, specifically the liver, and implanting it in mice is what they're doing. And they're basically creating what they call humanized mice so that they can sort of test different vaccines or different diseases and how they'll react in a humanized system inside a mouse. And obviously we find this very reprehensible, but also, as I mentioned before, the University of Minnesota has a very, very strict policy with regards to animal research. You have to go through this committee and you have to meet all these different standards. It's pages and pages long on the website. And also they recognize that people have varying, quote, moral viewpoints about research on animals. So how much more so on fetal tissue from human babies? So actually Representative ONeill asked the university, after all this research, what has been your result? And this is exactly what they told her, in her words. The first result, he told me, was that they used fetal thymus to implant into mice to transform them into humanized mice. After the mice have been transformed to have human immune systems, they give them AIDS, human AIDS. Then they have been testing pharmaceutical drugs to treat the AIDS. Results of the drugs being tested, he didn't say. So that's kind of where we're at here in Minnesota.
So most of this reflects sort of the state of the law and the state of the understanding of the human person. There seems to be a real lack of appreciation of the humanity of those aborted fetuses and their right to be treated as, at least after their death, to be treated with the same dignity and respect. As further evidence that this is a problem here in Minnesota, recall that when the large Planned Parenthood facility at the corner of Vandalia and University was built, there were a number of people who inquired about the possibility of installing in the sewer system catchers so that fetal body parts that might be washed down the drain could properly be caught and interned in accordance with the fetal disposition law. The response of Planned Parenthood officials to invoke state law which allowed them to close public access to the building plans that had actually been filed, as was required, with the city prior to construction. These sorts of concerns are real, and they show the truth of Mother Teresa's wisdom when she said that eventually we will fail to respect human life at any stage, given this. What we are asking is that Minnesota law be complied with, and what we're continuing to explore and to try to understand is why a university that refuses to use the research regarding hypothermia that came from Auschwitz and other death camps, because of an international moratorium on the use of that research, would justify the use of induced abortion fetal tissue. Is it that the international consensus and the national consensus have moved so far away? When you look at the medical journals, what we're seeing and the justification given by the Association of Medical Colleges is that, well, at least something good can come from whatever you characterize morally this process of induced abortion. And yet we know that that wasn't the position taken on the hypothermia research and other research lines that came out of Germany. Why is this okay and that's not? Have we really come so very far from the world consensus on the value of human life? At this point, we'd like to open it up to questions. And so I think in order to protect people's questions, I will simply repeat them so that it won't be recorded in your voice. And that way, I see some students here who perhaps are taking a position that's a little unpopular with their classmates, and I wouldn't want you subject to anything. We are filming this evening, so I would repeat the question. But are there questions? What can we answer for you about what we know now, where we hope to go, and how we would go forward? Yes, sir.
Well, if I understand what I heard earlier, you was just blowing off the state product. Is that accurate?
Well, arguably now they're saying that they will treat any fetal remains after research in a way that's consistent with the disposal aspect. What they are ignoring is that the products of an induced abortion, the only investigation that can be done is for the benefit of the health of the mother herself or her offspring. Now, we're not in a court of law yet, and I would anticipate that part of the arguments will be, well, whatever research benefits one will benefit all, etc. I would hope that Minnesota courts would look beyond that and would see that the legislative intent would be that it would be research directly benefiting this particular woman. But I suspect that's where the argument will go.
Obviously, they're fearful, probably need funding or something for them to be so vicious with having a big billboard. Because I've seen other ones too, just
So I think
it's interesting, if there's anything from a standpoint, from a media, how the U is taking this, because obviously you're ruffling some feathers with them.
I think you're exactly right. That billboard campaign, which there were billboards all over the metro area. It was a very, very expensive campaign. Started immediately after some of this stuff started coming to more public attention. And I think you're right. It's definitely a PR campaign. They're very concerned. And also the University of Minnesota, obviously, it's a public institution. It receives taxpayer money, which means a lot of the money that they receive has to come through the approval of the legislature. And the University of Minnesota is set to ask the legislature for yet another large sum of money. They already received a large sum of money in this past year, and they're set to ask for another large sum of money. And as I mentioned previously, the legislators, some of them are quite upset that they were lied to, or there was a very big miscommunication from the University of Minnesota when they were told, even when touring the research facility, that no fetal tissue research was conducted. So I think that the University of Minnesota will certainly have a lot of questions to answer from legislators come the next year when they go to ask for more funding.
we've also seen a change in the policy of Planned Parenthood nationally. When you watch all of the videos, the entire sequence of videos, it's very clear that there was concern at the highest level about whether or not a fetal tissue program should be part of the regular fetal tissue operations. And so in many states, there were no fetal tissue donation programs, no sale programs, however you want to characterize it, in part because, as is said on one of these videos by a Planned Parenthood official, the public response would be horrific. And they're quite right. Now, Planned Parenthood's new policy, they have always disavowed that they sold for a profit. They were simply recouping the cost of extracting the tissues from the fetal remains, according to their CEO. Now they are taking the position that they will not receive any funds at all in relationship to that. So that has been an interesting outcome that seems to evidence that there is at least a widespread perception that Planned Parenthood was indeed profiting. And anyone who's ever run a business enterprise will know if you can take something that is a cost to your enterprise, the disposition of fetal tissue, and turn it into even a break-even, that is a benefit financially. If you can turn it into more than that, the negotiating we saw in that first 4-minute clip, then you actually have a moneymaker, which is what some former employees of Planned Parenthood are suggesting. Abby Johnson down in Texas comes to mind. What else in Minnesota should be done, can be done, What is trying to be done?
Well, I mean, to be quite frank, we do have a hard climate to get things done because, as I'm sure you've heard in other states, governors and their administrations have been very willing to defund Planned Parenthood, to call for an ending of any of their state funds, usually through, or mostly through Medicaid, or at least to investigate them. In fact, for example, in South Carolina, the governor there finally ordered an investigation, not just of Planned Parenthood, but of what we were saying here in Minnesota. Governor Haley ordered an investigation of all abortion facilities. And what they discovered was violations of law that exceeded far beyond a fetal tissue program, but violations of Medicaid, meaning Medicaid fraud, other violations of law. There was a total of 27 violations, and 21 of those 27 were at the Planned Parenthoods alone. So here in Minnesota, we don't have an administration that is friendly to that. But we do have Planned Parenthood of Minnesota here. They're broken up into affiliates, and Planned Parenthood of Minnesota is actually called Planned Parenthood of Minnesota, North Dakota, and South Dakota. So we do have some legislators in other states who are looking into the Planned Parenthood facilities in their clinics in North Dakota and South Dakota. There's some conversations going on there. And certainly we need to keep the pressure on Governor Dayton and his administration. We need to make sure that we don't let up because there is a responsibility that the taxpayer-funded institution of the University of Minnesota owes to its taxpayers. And there's a duty that the governor owes to the taxpayers of the state as well. So keeping pressure on the governor, and then also at Minnesota Family Council on our website, mfc.org, we have a letter that you can actually send directly to the university president and the entire board of regents. The letter's already written for you. All you have to do is fill in your information, the return address information, and the letter will send automatically. And it basically asks the university to come into compliance with the law and also change their official fetal tissue research policy. So kind of as we were discussing before about the university's image, their PR campaign, the University of Minnesota loves babies, we need to continue to put the pressure on them because Professor Collett's right, this doesn't look very good for them. And we believe, obviously, that what they're doing is wrong. Even if you don't believe that fetal tissue research is wrong, certainly breaking state law is wrong. And so we want the university to come into compliance with state law. Keeping the pressure on them is very important, too.
The other thing that needs to come out of this is the fact that Minnesota has absolutely no clinic regulations. In 1974, Roe versus Wade came down in 1973. In 1974, a lawsuit by Dr. Jane Hodgson. Dr. Hodgson, of course, was a very prominent abortion physician in the Twin Cities area. There are numerous cases that are Hodgson versus Minnesota. Take your pick. But in Hodgson versus Lawson, the Eighth Circuit struck down the Minnesota clinic regulations as well as the post-viability ban in this state. In other words, in the state of Minnesota, an abortion is lawful at any point up until the moment of delivery. That has been a point that others have suggested is not accurate, but when shown the Hodgson versus Lawson case, there's been no response. There is no current effective law. When I was engaged in a dialogue with the head of Planned Parenthood of Minnesota, North Dakota, and South Dakota on Minnesota Public Radio, she kept saying, well, that's just not being done. Well, that may or may not be true. As I said to her, I don't run an abortion clinic. But what I can tell you is that there is no state official that has got legal authority to determine whether or not it's true. And even if it is true, there is no prohibition on doing an abortion at 34, 35, 36 weeks. So the simple fact is, not only do we need the University of Minnesota to adhere to our fetal disposition law, but we also need the ability for state authorities to go in and determine what is happening in these clinics. The ability to go in and determine if the sort of violations that were found in South Carolina, the sort of violations that were found in Texas that led to a multi-million-dollar settlement on behalf of Planned Parenthood, If those things are going on, and yet in Minnesota, notwithstanding strong pro-life majorities among the electorate, we have almost no protection against this sort of thing happening other than the disposition of the fetuses. But I ran over your question. Yes, ma'am. Yeah. Yes.
Pressure on Planned Parenthood with the US coming out, and then to shift the governor to begin an investigation into the house. So then the pressure from the University of Minnesota, which seems to be more of a downstream drive to market kind of a approach. Is there a way to capture all of these players in some kind of lawsuit, bringing in all the players as accessories to violations of Minnesota law?
The question being whether or not pressuring the U is sufficient, and is there some legal mechanism that we can not only require compliance by the law with the university and the regents, but also with the governor and with other public officials. And with Meadowbrook's successor, the clinic that was doing direct transfer to the University of Minnesota that we learned through these purchase orders. The fetal tissue disposition law creates two penalties. Number one, it's a misdemeanor. Number two, it's also declared a public nuisance. As a public nuisance, unfortunately, the state law in Minnesota is that private individuals cannot seek a court order to abate a public nuisance. Only the public officials in the community where that nuisance is occurring. So it is possible that the district attorney in Ramsey County could bring a lawsuit to abate the public nuisance, or that the district attorney in Hennepin County, because of Meadowbrook and other abortion clinics, could bring a lawsuit to abate. But again, the political barriers are significant. Similarly, criminal charges cannot be pursued by private individuals, and thank goodness for that. Who would want to get into a fuss with your neighbor and have them be able to? So that's a perfectly sound and sensible policy, but there doesn't, at least in that particular statute, appear to be a private cause of action. There may be other avenues to pursue, but on the face of the statute itself, the penalties do not allow public recourse other than the pressure that we put on our elected officials. John? Oh. Okay. Yes, ma'am. As a general rule, private citizens can seek particular common law writs, they're called writs, of assistance from the court to compel public officials to do their job. Minnesota's law on that is complex, and there's a lot to be explored. Whether the Minnesota Supreme Court, with its current composition, would actually accept such a writ, order such a writ, is an open question, but that certainly is something to look at. But there are certain preconditions that have to exist. So that's a long way of saying, in theory, maybe, but maybe not, and that's as far as I'm prepared to go at this time. Yes, ma'am. Question, is there anything in federal or state law that would require labeling of any product that is produced through the use of fetal tissue remains, fetal tissue research, et cetera? At this time, no. From my own personal experience, I know that our current federal administration is hiring several Center for Reproductive Rights lawyers into the Department of Justice Civil Rights Division. I know that there are numerous cases currently where the president and his administration are unwilling to enforce the law. There is a problem in California where the California state officials are trying to compel Catholic colleges to pay for induced abortion as a matter of insurance requirements. That is contrary to federal law. The procedure by which you complain on that is you go through the Department of Justice. That complaint has been pending before that agency for a number of months now. It's a violation on its face, and so there is a reasonable inference that they're dragging their feet on it. So I don't see this FDA issuing such regulations at this point in time, but could it be done? It absolutely could be done. Yeah. There are certain vaccines that used fetal tissue research that the pro-life community is aware of. We have documentation, et cetera. But let me be really clear about the pro-life center as part of a Catholic university's position, which is we are not vitalists and we are not Luddites. We are not opposed to research, and we don't believe that life should be maintained at every cost, and as long as there's some sort of electrical impulse at any point, then what we do believe, though, is that the human body has intrinsic dignity in that it is the incarnation. It is a mirror of the incarnation, and so we have deep, but the voluntary research, a grieving parent who chooses to have their stillborn child's liver donated in order to avoid those consequences in the future. It is my understanding, based on consultation with theologians, that that is not inconsistent with church teaching, and that would not be a position that the Pro-Life Center here at the university would take. It's the fact that these are induced abortions. It's the fact, and so I think the consumer knowledge is very important, but I think there's an important distinction to be made too in research into this area. State law reflects that sort of distinction, and how we go about becoming involved in a politically effective and palatable way to our fellow citizens, who I think are clearly appalled by this. 4,500 at our first rally.
Just to jump on that a little bit, I think that a lot of the research for vaccines or various drugs, what have you, is available online through various medical journals where they talk about the history of development, if that's something that you're interested in. But also the University of Minnesota as a public entity is subject to public information laws, which means if you make a request under the Minnesota Data Practices Act, basically just saying, under the Minnesota Data Practices Act, I'm requesting information on, what have you. They do need to supply that information to you so they can give you the research on whatever drug that was developed. Now, it might not have been developed at the University of Minnesota for your particular drug. We wouldn't know that, but you could make the request.
Other questions? Yes. The case that comes to mind immediately is Moore versus the Regents of UCLA. And in that case, the California Supreme Court confronted a situation in which a man who had a chromosomal abnormality related to his blood needed to have his, I believe it was his spleen removed. And the doctors at the research center were very excited in the same sort of way, sadly, that lawyers are very excited about very striking, grim facts because this is going to be a great case. All right, these doctors were very excited about this chromosomal abnormality because they thought it would hold the key to a cure in the future. They did not disclose this to the man that they were treating, and instead had his organ removed, retained it, and continued to require that he fly from his home in Washington State to California for post-operative monitoring when it was simple blood tests, temperature, those sorts of things that could have easily been done in his home state. They developed a remarkably successful commercial product that generated millions of dollars. The plaintiff sued in state district court saying that you have taken something from me. You converted my property. It's a tort claim. And so they filed a lawsuit. The reason they use tort rather than fraud is with fraud, all you can get is punitive damages. What the plaintiff in this case wanted was a cut of the profits, all right? And so he used property law in order to make his argument that this was my property, I came to you for care, you removed it, you then utilized it in a way that you did not inform me of. He could have claimed lack of informed consent. He could have claimed fraud. Instead, he chose conversion because the remedies were more financially valuable to him if he used this tort claim of action. The California Supreme Court, in a divided opinion, said that medical research is too important to allow patients to make these sorts of claims after the fact. Now, it seems to me that the aggravating factor of having him fly back from Washington State unnecessarily, they did require compensation. He was given damages for that, but they were unwilling to allow him to proceed with the conversion claim. The fraud claim, if we go back all the way to the federal statutes, the informed consent, when you consent to the research, one of the questions would be, how explicit does that consent for the woman have to be? There are no doubt many women who might well consent to the use of their fetal tissue if they thought it was going to save another child, if they thought it was going, they would not consent to put it in mice. And I'm acutely aware that there are physicians present and that research often begins through animal trials rather than human trials. And so I'm acutely aware of the justifications that can be offered for that. Notwithstanding that, consent feels different if you're asking me to create some sort of chimera for these purposes, as opposed to donating in order that there can be some sort of surgical intervention for another unborn child. So that is another avenue, is to look at the informed consent, not the patent, not the trademark, but the informed consent. And it may be that other states would come out differently on the conversion factor. I don't know, but California has reached that, and it's a leader in this area. Well, thank you very much for giving us this part of your evening. On Thursday at the lunch hour between 12:30 and 1:30, if you just want to hear it all again, you just can't stand not to hear it all again. And I'll even buy you lunch if you sign up on Eventbrite. At the law school, we will be doing a shorter presentation, but we wanted, what we're experiencing is, as a law school entity, few of our law schools students will make the journey over here, whereas if I offer to feed them at the law school, they will come. So, although with this presentation, they may wish I wasn't feeding them. But nonetheless, so Thursday, next semester, I'm very excited, we are going to focus on end of life. This semester, we've focused on the beginning of life. Next semester, we'll focus on the end of life. Part of which will include, for the first time ever, a reading group on a New York Times bestseller called Being Mortal. Those of you who are dealing with aging or dealing with aging parents who want to think about these issues are more than welcome. There will be an email sent out asking you if you'd like to join into these reading groups. And the book was a wonderful book by a Hindu neurosurgeon, but he's talking about how we deal with those last stages of life when perhaps our mental faculties fail us. And he touches on assisted suicide, but it's more like It's more about how do we make those lives really good to the very end? Why are we talking about a good death instead of a good life? And it's a wonderful, persuasive book aimed at sort of helping the American public think through those end-of-life questions. It's being co-sponsored by Campus Ministry, so fear not. We're not doing anything heterodox, although most people would say, knowing I'm the director, they would know better than that. And we're going to talk also about assisted suicide. We're going to talk about planning toward the end. So look for that program of, that series of programs. That'll be in February. We're trying to get this building because I know the parking is so much more convenient. Thank you for coming this evening. I'm very grateful. If you didn't get an email about these programs, please be sure and let me know so that I can make sure that you're added to the list. Thank you and good night.